Good morning, everyone. I think everybody should be coming in. We're just about to get started. It's 10 o'clock. Jim, if you'd like to get us started here, and we'll move on here.
Okay, great. Thank you. Good morning, everyone, as well. My name is Jim O'Donnell. I'm the Vice President of Operations for the Florida West Coast. On behalf of Vesta Property Services, I'd like to thank you all for taking the time to join us today for this update webinar concerning COVID-19. Partnering with Vesta for this conversation again is the law firm of McCabe Ronsman. McCabe Ronsman is a full-service law firm representing community associations throughout the state of Florida. It's my pleasure to introduce you now to the two attorneys who will be facilitating the discussion. First is Ed Ronsman, who is a partner and is board certified in condominium and plan development law. Ed has devoted his entire legal career to representing community associations throughout the state. The second is Jim Roach, who is also a partner representing condominium and community associations and developers. Jim's focus is providing general counsel legal services as well as representing associations in contested litigation. If you're in need of any legal counsel, by all means, please reach out to Ed or Jim and see what they can do to help you. Without any further delay, I'll turn it over to Ed and Jim to facilitate the conversation. Ed?
Thank you, Jim. Thank you to Vesta, too, for providing this webinar. I know we all met a little bit over a month ago when we first provided this update. We're all kind of scrambling to understand what's going on and how this impacts your community. And now that we've had a little bit of time, as you can see, the way that we've titled it, now we're looking at it with all the executive orders, and some of the restrictions being lifted, we're going to see how that's impacting your communities and trying to answer some questions you have. One thing, just for some of you that might be newer, if you haven't used Zoom yet, the way that we like to handle this is if you look, there's a Q&A button. You're able to click on that and then type a question. It will pop up to us. We're able to take some of the questions during it if it's kind of right at the point where we're at that subject matter in the presentation. But what we've been doing is holding a lot of the questions till the end. So please make sure to stay till the end after we get through the materials, and we'll be happy to answer your question. It is for informational purposes. We're happy to provide this update to you, and if we can assist your community specifically, a lot of it is community specific. Please feel free to reach out to us, and we'd be happy to work with you if that would work out for your community. So with that, what I'm going to do is I'm going to share, and we're going to start our PowerPoint here. Everybody should be able to see the PowerPoint. We will have our email addresses on at the end, as well as Jim's email address, the email addresses of the Vesta VPs that have been involved with these webinars. So please feel free to email us if you'd like a copy of the PowerPoint. You can also see in the top that we're recording this. I know that Vesta has been making this recording available so that if you are unable, or if you drop off for some reason, or if you have any board members or anybody you work with that would like to view it, we're going to be making that available too. So an overview of what we're going to be talking about. We want to talk about what current orders are in place. We're going to be talking about reopening amenities in the community. That kind of flows from the current orders that are in place and the lifting of certain restrictions. So that will flow from the first point to the next point. We'll talk about some contractual issues that we've seen and that you might have come up as for your community association as part of your day-to-day operations. And then we're going to talk about the long-term effects in terms of financial issues, collections, possible statutory changes, some recommendations that we've seen, maybe with how you're holding your annual meetings as well. So going into the status of the current orders in place, and I know that we have, for this is really the west part of the state, we'll talk a little bit about some local orders, but generally Jim's going to talk about the executive order from the governor here.
So regarding orders from the governor and the recent order, the phase 1 reopening order, there are three main issues that I think primarily relate to community associations or would affect community associations. One are amenities such as gyms, fitness centers, and pools, the topic of vacation rentals, and preemption, meaning whether the new executive order supersedes orders from local governments. So with regard to amenities, the executive order does not require amenities of residential buildings to be closed, meaning the state, again, the governor's executive order does not require that. But you still have to look at local government orders, such as cities and counties, because when we get to the issue of preemption, you'll see that there's no express intent for the governor's orders to supersede or preempt local government orders. So as a bottom line there, the amenities of a residential buildings, which are probably most of you, they're not required to be closed by the governor's orders. The new executive order also extends the previous executive order 2071, but that order never applied to gyms, fitness centers, or pools, which are an amenity of a residential building, which again will likely apply to most of you. And it's important to understand that the question of whether the association is legally obligated to close an amenity and whether it should close an amenity are separate questions. So with that being said, we'll go to the next topic of vacation rentals. So the new executive order extends prohibitions on vacation rentals as provided by the previous order 2087. And 2087 prohibits parties engaged in the rental of vacation rental properties, and it cites to a specific statute in defining that term. And it prohibits them from making new reservations, with some exceptions. It also provides that the prohibition shall include the rental of any house, condominium, cooperative, or dwelling unit that's also a transient public lodging establishment, as that term is defined by law. And again, there are exceptions for rentals to persons performing military, emergency, governmental, health, or infrastructure response, or travelers engaged in non-vacation commercial activities, whatever that word's supposed to mean. Those are not prohibited by the new executive order.
One thing too, just to bring up, I've seen this happen with some of our communities where we've been seeing rental agencies asking the owners of units to fill out something that basically says that, yes, I have a renter in my unit that might otherwise be for a short term, but they're in the act of performing in one of these things, whether it's a military, but really it's for some type of infrastructure response or a traveler engaged in non-vacation commercial activities. I received a call yesterday from an owner that essentially stated that his rental agent asked him to sign this without having any knowledge of whether or not that was the case for his renter. So the reason why, of course, is that the rental agencies have some liability here. You can file, there's an impact on their license if it's reported to the DBPR because they're licensed through the state. And so they're trying to protect themselves. And so from an association standpoint, it's difficult to maybe get behind that of whether or not that's accurate, just like other things that you see in your community that aren't related to COVID-19 where people state, I mean, probably the most common thing that I've seen where people are just signing off on stuff that they don't really understand or haven't gone through the proper process is if they need a support animal, for example, and you go and they treat with somebody out in California virtually for 20 minutes and now that person basically told them, just sign this form and your HOA is going to have to allow you to have this dog, for example. So I see the same type of issues maybe coming from that. And from a practical standpoint of being able to enforce it, it would be difficult. The other thing too, and what we'll talk about a lot today that you're going to hear us mention is that it's usually not the association's role to enforce this anyways. The only way that you could is if you had some type of language in your governing documents, maybe for, that you can enforce for any violation of a law or ordinance or something like that. So even if it is in violation, whether or not the association has standing to bring that versus reporting it to law enforcement is another question. So just be mindful. I've seen this popping up more for the exceptions that where it is permissible and whether or not they're actually performing these services. And even if you can't prove that, what action can the association actually take?
Right. So in addition to having exceptions, it's important to understand what exactly a vacation rental is as it's defined by that order. So some types of rentals just simply aren't vacation rentals. It's not that they're an exclusion, but they're not a vacation rental in the first instance. So we've included two statutory provisions which were cited in the governor's orders to help define the words that were used in there. So you can look at those statutes and essentially even a rental of a short-term duration, like for fewer than 30 days, if an owner does that on a one-off basis and doesn't do that more than 3 times in a calendar year, then that's still not a vacation rental as the governor has defined it. So the number of times that unit is rented in a given year also matters as it concerns whether it falls within the definition of vacation rental. But to generally summarize, if a rental is to an exempt person, or if the rental is for fewer than 30 days or 1 month, but the unit isn't rented for more than 3 times in a calendar year for that, for periods of fewer than 30 days or a month, or if the rental's for a period of greater than 30 days or 1 month, then the executive order doesn't prohibit the rental. However, it's also important to understand that the executive order doesn't permit a rental that would otherwise be prohibited by your governing documents. In other words, if you have a minimum 6-month lease term provision in your governing documents for your community, then this executive order wouldn't otherwise permit someone to, short-term rent to, a first responder or something like that. There are words of prohibition, not permission. So a few final points on vacation rentals, and Ed touched on this a little bit earlier. If the association doesn't have tenant or lease approval authority in its governing documents, then the executive order doesn't grant any of those enforcement powers, or doesn't grant authority that the association doesn't otherwise have. And in that case, it's not the association's role to attempt to enforce law or executive orders. In that case, contact law enforcement, or in the case of a rental agency or an entity licensed by the DVPR, contact the DVPR if you believe that executive order is being violated. On the other hand, if the association does have tenant or lease approval authority, or if there's a compliance with law provision in the governing documents, basically stating that people occupying any portion of the property must comply with law, then the association might have the option of either contacting law enforcement if they believe the order's been violated, or they can institute covenant enforcement or rule proceedings, or a combination of the two. But from a practical standpoint, it's difficult to get to court on a non-emergency basis. A court certainly wouldn't consider any of this kind of rental issue to be an emergency. So by the time you're not going to prohibit people on the front end, likely. It's likely going to be, punishing on the back end, if you will. Right? So keep in mind that practical limitations exist as well.
So take a look at your governing documents. In order to enforce anything with this, if you're trying to basically enforce if there's a violation of the executive order regarding the short-term rentals, the vacation rentals, if it does apply to your community otherwise, you still need to have that language like in the second bullet point there. And even then, talk with your attorney before you go forward with it. You need to go through the appropriate procedures. If you're going to fine them, for example, you have to approve the fine in a board meeting, and then you have to give them at least 14 days notice for a hearing before what's called the covenant enforcement or the fining committee. And perhaps by sending them that notification that you're going to be doing that may stop the activity. But like Jim said, it's tough to do it in the moment to stop the unlawful rental, for example. Contact law enforcement. They're in a better position to come in and do something immediately. The best thing the association can do is send notification and then kind of get it on the back end, at least from a financial standpoint, where if an owner sees, hey, I could be fined for this potentially, that might stop the activity.
Okay, and the third issue contemplated by the governor's order as it relates to community associations is the issue of preemption, and the question of whether the governor's new executive order preempts or supersedes local executive orders or local law. So unlike executive orders 2091 and as clarified by 2092, nothing in the new order expresses an intent to preempt or supersede local law. Meaning that you still have to look at your local jurisdictions, cities and counties, to see what they're doing or what they're purporting to do in terms of executive orders, and determine whether you need to comply with those as well. Also, the order expressly does not apply to Miami-Dade, Broward, and Palm Beach County. Essentially, the governor thought that those local governors and local jurisdictions are best suited to deal with a more isolated problem in their particular jurisdictions. There might be a higher concentration of the virus in those areas. So the governor, from the state standpoint, didn't want to mandate or dictate what those local jurisdictions would have to do. So he's giving them the ability to protect themselves or do what they want to do individually and locally. Also, the frequently asked questions attached to the new executive order state that local authorities are allowed to adopt requirements directly on businesses, operations, or venues, including buildings, beaches, and parks that are stricter than the governor's orders. So the bottom line is that associations must still review local law, including executive orders that are issued by local governing authorities, and determine whether and how they must comply with them.
The other thing too, going along with and still talking about that, even if you're going to put yourself in the position of trying to enforce the executive order or any local law or ordinance, because maybe you have that language that we mentioned where it says that you must be in compliance with local law and ordinances and so on. there's still the argument of whether or not some of these are even constitutional, for example. And that's a whole other analysis, is why you need to talk to your attorney about it, because you could piggyback off and say, well, look, the governor said that you're not allowed to do this, right? Well, what if the governor's executive order isn't constitutional? There's been a lot of chatter amongst, especially from rental agencies, that why are you treating vacation rentals within communities or anything else differently from a hotel or motel or other, some type of a more, commercial venture. I don't know if you want to call it that, but why are you distinguishing these? And there's a takings argument, right? That there should be some type of payment made from the state if you're going to be doing that. And so there's some question as to whether or not it's a valid executive order. We can't really go into all of that. That wouldn't be the purpose of this today. Just know that even piggybacking off of what current law is in place, there could be ramifications for the association in trying to enforce it if it's found that that executive order was unlawful in some way, because then that then ties down to the association trying to use that to enforce its governing documents.
Right, and similarly, there are freedom of association arguments when their executive order is trying to limit the number of people gathering in any location, which raises First Amendment concerns. So again, we can't go through all the constitutional analysis here, but just understand that in situations like these, they stress the boundaries of our constitutions and the limits of the authority of government. So like Ed said, you bear some risk if you try to piggyback and enforce what purports to be a law or an executive order. Well, then you also bear the risk of that order being held unconstitutional, in which case your claim might fail.
So again, just saying, talk to your attorney that you're working with. We're happy to assist with your communities if you need legal advice on it, because there are some, maybe beyond what you might think, there are more facets that go into it in terms of enforceability and what position the association is going to be in on it. So I think we're going to go to the next one. I'll take a look at if we have any questions that relate to some of the questions come up. Ken says the governor has canceled all rentals. When do you think they will open up again? I think there is no expiration for that right now, correct?
No, and it's not all rentals. It's just
the short-term
rentals. Yeah,
right.
Otherwise, we could only speculate as to when the governor might take other action.
Yeah. Let's see. They're issued pool guidelines for CDC proper cleaning and disinfecting the pool each day and at regular intervals while the pool is open. If an association prior to COVID-19 had once a week cleaning schedule, are they now required to abide by the guidelines in order to open the pool? The cost for the extra cleaning can be prohibitive. So we would need to take a look at the guidelines and the protocol, and then any type of local order that's in place of whether or not that's implicated. I know that we were discussing in the Pinellas County, the most recent order, I think that was within the last week or so, there was a line in there that said that anything that's reopened, and they include community association pools, should be cleaned pursuant to CDC guidelines. We would need to take a look at that to advise as to whether or not, again, if it's applicable to community associations, can they require that for associations that reopen their pools, for example?
Yeah, and depending on the nature of the pool owner and who can use it, there are different regulations that apply to them, and these local jurisdictions don't always know that. They might just shoehorn the association's pool into the same category as a commercial pool. So, and if you just contact these local government agencies and representatives, they don't understand all of those nuances. So they might just give you general information that might not be perfectly accurate for you.
Ken asks if rental is for more than 30 days, is it not subject to the executive order? I mean, that's correct. That executive order only deals with 30 days or 1 calendar month or less for rentals, and then for transient lodging, essentially. So anything longer than that, the executive order doesn't touch that. Let's see. I think we'll keep some of these questions. These are some good questions we'll handle at the end because they're more general in nature. Okay, so reopening amenities in the community. Can we reopen and should we? So the answer is, and I'm going to say this, that it's a real lawyer answer here. It depends on the local order still in place, and it depends on what the board wants to do and what the risk tolerance is for the board in the decision making. So we need to take a look at the local orders. Some of them, I know in Pinellas County that they've allowed the reopening of pools, which includes allowing community associations to reopen their pools, but it has to be, I believe, at 50% capacity, and then we discussed some of the cleaning guidelines for it. So that just permits it to take place. The question is, do you have to then reopen it? Does that order require pools to reopen? I would say the answer is no. It does not require it. It permits it. So it still comes into the focus of the board as to whether or not it wants to take the action of reopening the pool and the amenities if it otherwise had been closed down. The reason is, if you have to take a look at it, is that the board is responsible for the operation and the maintenance of the common areas and amenities generally. You have to take a look at your governing documents, but that's typically what it is for every community that we work with. So in that regard, the board is charged with acting in the best interest of its members and making decisions on a reasonable basis, relying upon proper professionals, healthcare providers for this circumstance. And so as long as the board is being diligent and relying upon the advice of professionals, it has pretty broad authority as to what it can be doing in this circumstance, in our opinion. Now, does that mean that there's a right or wrong answer as to whether or not you should open or you shouldn't open? We've talked about this. We as attorneys, we have not told our clients, yes, you should open, or no, you should stay closed. What we've been giving advice is, look, we can understand if you were to open it, the purpose for it is that members have easement rights and use for the common areas and the amenities. They certainly have that right. It's reflected in the governing documents. It's an amenity. It's a service that's provided by the community. So if you were to reopen it, what we've been advising is to provide some disclaimer language as to you're using it at your own risk. Please abide by the CDC guidelines in terms of social distancing, gatherings of 10 people or less, that sort of thing. That's the type of advice that we've given. If communities have said, well, what if we want to keep our amenities closed? Is there support for that? And we think that there is support for it. There's potential challenges, but the support for it is, if you as the board have the ability to determine, and pass rules regarding the use of the amenities and the common areas, it would stand that if so many people are saying, look, it's not safe for people to be gathering, and you see people, your pools are built for a certain capacity limit that people tend to gather, and if you, in your business judgment, think that it's better to keep them closed, I think there's certainly support for it. Does that mean that you could be that you won't be sued for it? No. Somebody could still, if they really felt like it, they could sue and say, look, this is an unreasonable rule, and I should be allowed to use the amenities that I purchased and that I paid dues for. I mean, somebody's going to raise that argument. They're going to say that that's the reason why I bought in here, because of these great amenities, and you're depriving my ability to use those amenities. So if you were to keep them closed, we would then talk with the association to say, here's the reasoning for it. You have the general maintenance and operation authority. Then you have the emergency rules. We'll talk about that a little bit. It's really that first bullet point under the second main bullet point here, which, if the emergency powers are exercisable, which is debatable, and I'll mention that in just a second, then that would include the ability to determine property off limits to use. So real quick regarding the emergency powers, you have that under Chapter 718 for condos, for co-ops under 719, and then 720 for HOAs. And in all of those, there's a provision that allows the board to determine certain property off limits for use. That's basically the support, I think, that some communities and that we've been using, if you were to use it for justification for closing down your amenities, is this emergency power. The question as to whether or not it's applicable, that's why I said it's debatable, because the statute is worded that it's in response to property damage, not necessarily as to anything regarding a pandemic. And I think it's really more, hey, there's been some damage to the property. It's not safe for you to go there because, there's a roof down, or it's unsafe. You've got debris from a storm or something like that. We don't want you using it. It's kind of unprecedented right now in a pandemic where no problem with the property itself. It's in pristine condition. We don't want people using it, though, because of the way that it would be used. And that would be the argument for it. So there's questions as to whether or not those emergency powers are exercisable. The DBPR, the Department of Business and Professional Regulations, with its division for condominiums, timeshares, and mobile homes, has stated that they interpret the statutes to be applicable in the instance of a pandemic, but they've essentially extended the language of the statute beyond what the statute actually says. So that's where we think that there's going to be a change to the emergency powers provision later on to encompass this, but it's not 100% clear. So all of this is a long-winded way to say there isn't a good answer to say, should you open or should you not open? I think it comes down to what we do as attorneys is we work with the board, which is the entity that we work with on behalf of the association, to say, what is your risk tolerance? What are you hoping to accomplish? And if you're going this way, if this is the action that you want to take, this is what we'd recommend from a communication standpoint, from a signage standpoint, that sort of thing. Jim, do you have anything you want to add on that?
Yeah, and part of it is, addressing the question of can we or can't we reopen? Well, that's a perfectly acceptable legal question that we can respond to. But the question of should we, is more of a judgment decision. And our role as lawyers is to help you make the decision, right? I often say we sit in the passenger seat and we have a roadmap, right? But ultimately we can't touch the wheel. You're the one who has to drive, and it's not appropriate for us to take the wheel. So we're sitting here looking at the roadmap saying, well, there's some construction on this road if you're to go this way, and this way is a longer way and a more roundabout way, right? That's us helping you understand what the risks are. But ultimately, you're going to have to choose which direction to go in. And that can include factors such as the geographic location of your community, whether anyone's reported exposure to the virus in your community or in a close geographic proximity, and also your level of tolerance to risk. Because either way you go, as in many association decisions, there's going to be some risk associated with it. If you don't open them, then people can complain that you're interfering with their easement rights or whatever rights they have to use those amenities. If you do open it and someone's exposed to COVID and within the premises, or at least alleges to have been exposed, well, then you have a risk of liability there too. So you're between a bit of a rock and a hard place. So you have to consider those factors as they apply to your community. And ultimately, we can try to help you justify and ultimately defend those decisions once you make them.
So going into it, talking about notice to owners, the big thing that we've been talking to our clients about is communication, how it's being conveyed, what are you expressing as an association. Any communication provided to owners should be carefully worded. We generally recommend including some type of disclaimer language regarding the use of common areas and common elements. Even if you have certain areas that you never close down that are still open for use, you could say, hey, you can use this green space, or obviously we're not going to be closing down the elevators, for example, but please be cognizant of the fact that other people are using the elevators, and you might want to use hand sanitizer. We're not here. We're not wiping down the elevator after every use by somebody every time somebody pushes a button, for example. So disclaimer language, and that goes then, especially if you're going to be reopening your amenities, we'd recommend some notification going out to the members, keeping them updated as to what's going on, as well as some signage for the amenities that might be reopened, saying, if you are going to reopen it, we recommend some type of disclaimer saying, look, you use it at your own risk. We don't warrant, that this is free from any virus or communicable disease, and we don't undertake the duty to prevent the spread of it. It's eventually saying, use common sense, don't expect us. And I know that it's got to be appropriately worded, I guess, because you don't want to come off saying, we don't care about you, we don't care about the spread of it. That's not the intent. The intent of that communication is to basically say, please don't expect us to be out here watching everybody and quick running everything and sanitizing everything after every use. That's not what our job is as an association. You need to use some common sense. Bring your own Clorox wipes if you're concerned about it. Bring your own hand sanitizer. But that's not something that we're providing as an association. I think you want to provide it. I think there's a general tendency, and it's understandable, to say, hey, this is what we're doing. We're stepping up our cleaning schedule. We're doing this. We're closing this down because we are committed to the health, safety, and welfare, and we want to prevent the spread of this disease. On one hand, I certainly understand why that message would want to go out. What we're looking at from a liability standpoint is, what if somebody contracts the disease and they can come back and say, well, I've only been in the community, and you said that you're going to prevent the spread of it, so therefore you seem to have failed in your duty. I'm going to sue you for damages from it, whether it's health bills or, of course, if somebody dies or something like that, like a wrongful death action. And that doesn't mean that you can stop somebody from suing you, but what we're trying to do is prevent any type of additional liability or make it likelihood that that lawsuit would succeed, or the value of such a case, for example, something like that. All right. Going into vendor access, this is something that's been brought up as well. We think that there's potential liability for not allowing vendors. There could be contractual damages incurred by owners if they have a contract for any type of repair or job that's going on at their property. I understand, again, why you'd want to prevent vendors, especially in like a closed environment, like a condominium association, because you have more people coming into your community. You don't know where they've been. You have to weigh that with the claims that owners may have of saying, look, I'm tied to this contract. You're not allowing this person. And what if they say that I'm going to come in, I'm going to wear a mask, I'm going to wear gloves, I'm going to certify that we're making sure that none of our employees, we temperature check them every day. If they can provide that there are safeguards in place, but you're still not allowing it, is that a reasonable stance for the association to take? And could you be subject to damages if an owner were to come and sue you by saying, look, I breached my agreement because I didn't pay them because they weren't able to perform work because you didn't allow them in, something like that. That could be a grounds for liability. The other thing is just unforeseen potentially, and this is the example I keep giving, what if there's some type of a parcel delivery service or some type of delivery or a medical professional that needs to come in and they're unable to because there's some blanket ban for not allowing outsiders in and somebody dies because they can't receive medical supplies or medical treatment. That's kind of an extreme example, but it's something to be thinking about of whether or not we should be denying access to vendors. If the question is, well, we're worried about the vendors coming after us if they touch our keypad, let everybody know, post a sign that says, look, you're entering at your own risk. While we have a cleaning schedule, we're not we cannot prevent the spread of this disease, nor do we undertake the duty to try to do that. So again, you're entering at your own risk, something like that from a communication standpoint. All right, so going into some contractual issues that we've seen, and I can use some examples that I've had with some communities. A review of contractual terms is imperative for ongoing services. Take a look at the contract that you have and the companies that you're working with. We've been working with communities that have had ongoing projects that have started prior to COVID-19, and basically it's led to some type of a shift in terms of what are you doing to protect our community with the workers that you're sending out. An example I can give is a large 10-story condominium association that I represent that had started doing a painting and an exterior restoration project months before this started, but it's been ongoing since. And the board said, hey, Ed, can we contact them? Can we require them to limit their crew? Can we require them to submit to all these things like a temperature check each day, requiring them to wear masks and gloves at all times, wash their hands? And my response was, it's not really in your contract, nor should many of you have that in your contract, just because we're all in kind of uncharted territory from a pandemic standpoint. You may see some of that in the future, and that might be a contractual provision that you might want to look at when you're negotiating with somebody. But for the time being, we don't see that as something that you can enforce from a contractual standpoint. Now, that being said, most businesses are being smart with this and saying, look, I don't want to be the business that's seen as, hey, I don't care what you say, I'm coming in and doing my work, and if you don't allow me to do it, I'm going to sue you for it. I don't care about any ongoing relationship with you. Most of your vendors that you're working with, they might know that they're going to need to come back and be asked to bid on services in the future. They're not going to want to be remembered as somebody that, you know, was going against the advice of healthcare professionals. And so typically I've been finding they've been able to work with you. So while you may not be able to mandate it, I certainly think it's appropriate to reach out to them and say, we would request that can you provide us with what procedures are in place for you internally as a company? And can we look at those, and can you commit that you're going to be continuing to do that for our community, for example? So that goes into, can you dictate how the work will be performed? Jim, do you have anything else on that one?
Yeah, so in this situation, we're talking about primarily vendors from the standpoint of contracting parties with the association. In the prior slide, we were really talking about vendors in the context of individual unit or lot owners and any contracts they may have with third parties. So you might have a little more leverage in contracts that you have directly as the association with third parties. And again, I think Ed's right on the practical leverage issue. You know, are there provisions in your contract with them allowing you to mandate certain, you know, the procedures by which they perform the work? Maybe, but likely not. But do you have practical leverage because these contractors want to work for you again, or maybe want to maintain a good relationship with your management company? I think so.
So, and I think this goes into a question that we had here. What is the best advice on beginning to allow cleaning people and contractors that the HOA is prohibited except on an emergency basis in the past 6 to 7 weeks? I think it depends on your community. It depends on what you're looking to accomplish. If you've had that, I'm not sure if that's for that the HOA has contracted with, or if that's for you're not allowing owners that maybe have had those services coming in. I certainly think it's worth looking at and weighing, you know, protecting your membership, but also understanding that people are able to contract with certain vendors and contractors, and that they should be able to allow, and maybe you have some procedure in place where they're required to notify you. I mean, that would need to be something you'd want to talk to your manager and your attorney about, because there's a potential for liability. Anything that you're not allowing an owner or their guests or invitees normal access to the community is going to give rise to potential liability, because that owner may say, you're not allowing me to use the unit in the way, or the property in the way that I should be allowed to do, so you should have a good reason for it. So I think that it's very important that you take a look at that and craft it in a way that you think about the potential ramifications, and is what you're doing reasonable? Are you providing notice so that your owners are on board? At least, even if they don't agree with it, they understand, so that there's no question from a communication standpoint. So I know that's not a specific answer. I think it depends on your community. Jim, did you have any thoughts on that?
Yeah, and I think it's, you know, in the homeowners association context, where you have like maybe single family homes, you're not really as close to each other. I think there's less of a supportable basis to be preventing those kind of people from accessing the community than there might be in a condominium context,
Right.
where you share more, part of the facilities.
Yeah. All right. All right, the force majeure clause, generally the performance or delay in performance of an obligation under a contract, it may be excused when it's impossible, impracticable, or financially infeasible. Typically that's through a force majeure clause, and the force majeure serves to excuse performance as a result of an act of God, war, strike, riot, etc. So some of you have probably heard of this. There's been some question as to what the applicability is in the community association context. The answer is that it's very document specific, and you have to have specific language. And there's case law on this that says it has to be explicitly provided in the contract. So in other words, a force majeure clause does not automatically apply unless you have language to the contrary. It's actually that you actually have to have the language explicitly providing for it in your contract, and the specific wording is important as to the event. So many contracts don't have language regarding pandemics, for example. And so while you may have a force majeure clause that may excuse performance by one party under the contract, if it's not specific as to what we're going through right now, that provision may not apply to this circumstance. So the specific wording is very important. You'd have to take a look at that. If you have broader language that, maybe it doesn't say pandemic specifically, but some type of, I don't know, you probably want to use the word pandemic, right? I mean,
Yeah, or like an order of a governmental prohibition by a governmental authority, that might be able to be usable in that circumstance.
Yeah. Typical, what we found though is from the force majeure clause, it's from an association context. It's usually it's more likely to be used by an entity that you've contracted with, and for them excusing performance, saying, hey, we thought we were going to get this painting done within 6 months, and a lot of times you should have that in your contract, so you've got an end date, and you can have a liquidated damages provision if they go past that date. It's usually the contractors that will say, hey, I was unable to perform, if a hurricane comes through, for example, right? And they have that provision, that excuses performance, or if it's delayed performance for them, or if there's a hard rain or a nor'easter or something like that that's come in that's delayed it, that may be something that applies. It's not necessarily for the association. There may be certain instances, for example, that could be, I suppose, in a hurricane where your building has been torn down. Hopefully that doesn't happen, of course, and if you contracted for a big restoration project in the building, well, you're not really going to need to go through that restoration project anymore. And so if you had a force majeure clause, that would excuse performance. It would be impossible for the association to perform. That may be an instance where the association would look to use it. But most times, though, it's on the other side that who you're contracting with. So that's where we would see that pop up. All right, so going into the long-term effects, we talked about this if you were with us at the beginning of this, where we provided this webinar at the end of March or the beginning of April. Collections and financial issues. Everybody has seen, or you've probably seen in the news, the impact, the unemployment numbers, how those have been going up. I think, I can't remember what the number is, over 20, is it 20 or 30 million?
Well, one number I read was 30 million nationwide.
Yeah. And so obviously that's going to have an impact on the economy and the ability to pay assessments. It trickles down to owners if they're furloughed, or if they've been fired, or they don't have income coming in, it's going to affect their ability to pay assessments. And that's obviously going to impact your community. And I've been calling it kind of like a lagging indicator in terms of you're not going to see it necessarily right now, but you're going to see it 3 or 4 months from now, when financial difficulties for people that maybe were laid off in April or May, or whatever the time period was, that maybe they're able to pay assessments, or if they're on a quarterly basis or even an annual basis, you might not see until next year. If you're on a monthly basis, it might be a little bit more immediate. And so I think the association, what we've been recommending is to have some type of a collection policy for the objective handling of delinquencies. And I say objective handling because it's common that you might have a neighbor that's going through some hard times, and you might want to maybe give them a break differently from somebody that you don't know on the other side of the community. It's important to be objective and to treat people uniformly, to avoid any argument that there's selective treatment or bias that's being shown to somebody, and that might impact your ability to treat somebody that might, I don't want to say more severely, but might not be as lenient as your neighbor, for example. So you need to have some type of a collection policy. It gives clear direction to management. I know we have a lot of people from Vesta on the call here. I know that it helps from a management perspective to not have to feel like, okay, do I need to go through and ask and spend an hour every week talking to the board members about what do you want to do with this account? What do you want to do with this account if somebody's delinquent? Having some type of a collection policy makes it easier for uniform treatment and streamlined, sending notices out. Now, We would also recommend avoiding a waiver of payment of assessments or late fees. We're advising against a proactive policy on that. What we've been recommending is if somebody contacts you and they request some type of a payment plan, I think something like that would be permissible. Take a look at that owner's circumstance. And if you're getting a lot of requests from that, maybe you do have a policy of, hey, we will extend the time period before we apply late fees and interest on the accounts, for example. That may be something that's permissible, but don't waive assessments or late fees or interest on an association-wide basis, because you might be giving up your ability to collect if that owner eventually has to sell the property, or if it goes through foreclosure and that new owner comes in, they are liable to pay those amounts. You don't want to make it seem like you waive your ability to collect those based upon a uniform policy. Another thing, electronic voting. What we've been finding is a lot of communities that were supposed to have their annual meeting in the spring, they've either postponed or they've canceled it and they're going to reschedule it. And some communities have gone to the electronic voting method. Ultimately, what we've been advising our clients is you still need to have, if you're going to have an annual meeting where there's going to be an election, it needs to have a physical location. That's the advice that we've been giving our clients. Some attorneys have been giving different advice, but the way that we see it is because of the fact that there's a voting right of the owner, they should have the ability to go up and hand in a ballot or a proxy or whatever the voting instrument is on the day of the meeting, and not rely on some type of completely virtual meeting because the statute doesn't really apply for it. I've been giving the advice, I think, and we as a firm have stated that it's defensible to have a virtual board meeting. There's still room for challenge, of course, from an owner on that. But that's because it's the board that's the voting entity rather than the membership. And board members are able to vote even if they're not there physically in person. They're able to vote over the telephone. They're able to vote by FaceTime or Zoom, for example. That it comes down to what's the entity, who is the person that's able to vote on an issue. And because board members have already been able to vote without being present in person, I've been giving the advice that I think it's defensible to have these board meetings virtually, because you don't want to have the instance, in my opinion, of having meetings where you're not having meetings and you're doing everything by email, where the membership is not able to participate. So if you're kind of forced with, well, we don't want to have a physical board meeting right now because it's not safe and there's not really a way to prevent people and we want people to participate in it, I'd rather them have a virtual board meeting where members can participate electronically, dial in, telephone or by Zoom, than having the board vote on everything by email and not have the members be able to participate at all. I mean, that's the way that you look at it. Again, potential for challenge. It doesn't say in the statute or the emergency powers that you're able to have completely virtual board meetings, but the fact that the board has the ability to vote not in person has made it easier for me to give that advice to clients. But that's contrary to, and Jim, do you want to touch on it again, kind of the membership meetings and the kind of the ramifications for that?
Right. So even if the emergency powers were deemed to apply, they don't have anything in them, in those statutes, changing the way that you would ordinarily have to hold a meeting. So nothing otherwise abrogates the physical meeting location requirement. So essentially, by conducting certain or trying to conduct certain meetings, particularly membership meetings, fully electronically, unless you go through the electronic voting procedures, which generally requires the board to adopt a resolution and members to expressly consent in writing to opt into those procedures, it can be argued that you're essentially forcing people through an electronic process, where the statute otherwise requires their written consent to participate in that manner. So particularly for membership meetings, there are things like, especially in the Condominium Act, again, in the HOA context, your elections can be much different and it's governing document dependent. But members, for example, have the right to personally cast their ballot at the annual meeting and election at the location, right? So arguably there has to be that opportunity until last call for ballots. And similarly, the association and the condominium context is statutorily required, but you're supposed to have that committee of people who count ballots, right? And there are arbitration decisions which the arbitrators have required the association to conduct a new election where there are improprieties, at least in the arbitrator's view, of how those ballots are counted. For example, there's at least one case where the committee went to a different room than the annual meeting and counted the ballots in a different room, right? So these are some of the issues that we're concerned about. So going back to the electronic voting, one option is to consider implementing that for your community. Now, there are some pluses and minuses with that. If not everyone opts in, then you still have to have a non-electronic process, but at least it mitigates the likelihood that people will personally attend. So to expand on that just a little bit, you can have an opportunity for a physical location to satisfy the technical statutory requirements, while at the same time encouraging people not to participate in that way and providing alternative methods such as, the Zoom information or conference call information, and encouraging people, even if you're not mandating it, that they participate in that manner.
All right. So again, electronic voting, the big thing is if you're in a community that is even looking to have your election in the fall, for example, I think it's important to look at the electronic voting process. You don't have to amend your bylaws. It's a board resolution. It's something that can be done without even having a membership meeting. And it allows you the ability to do it so that even if you're going to have a physical location for the annual meeting to take place, what some communities, even some that we represent, I went to one where we all were social distancing, nobody was close to each other, but they held it and they basically asked members, hey, please feel free if you can drop off your ballot or your proxy or whatever the voting instrument is. We're going to be here. We'll take that, and we're going to have a couple. I would call it a skeleton crew. Basically, you have a couple of the board members, the manager, enough to be able to count the ballots if necessary. But we would ask for you to then leave and go home and view this via Zoom or telephone conference. I think that may be the way that some communities are still going to handle it in the fall. It just depends on what we see with the spread of the virus. And what orders are in place, if there's a hot spot that pops back up and we have to ramp back down again in terms of social distancing. So I think if you're in a community that condo or HOA that are going to have an election in the fall and you don't provide for electronic voting, I think it's worth looking at it right now. There is a little bit of time to get it set up. You want to talk with, there's a bunch of vendors. We work with some, our firm does not provide that service, but we can recommend you to some vendors that we've seen that done a good job for communities. And get that process in place. There is a method that owners do have to opt into electronic voting. So you want to have that time to be able to send it out and give people enough time to opt in before the actual vote takes place. But having the electronic voting, I think, makes it more likely that people will not show up for that annual meeting if they know that they can go in and click on their computer to vote, not even have to mail anything back in, for example. So strongly consider taking a look at that for your association if you haven't done so already. And then, I think the last thing we have here is what are some possible statutory changes? What could we see come out of this? I could see some statutory changes as to the emergency powers. We've talked about that it talks about property damage, not necessarily anything related to a pandemic or any other type of state of emergency that doesn't apply to property damage. I could see that being added, certainly, probably next legislative session, I can imagine that'll be added. The next one is really allowing completely virtual board and membership meetings. We've talked about that in terms of there's kind of a void there. It's not even that the emergency powers allow you to do it. What the emergency powers allow in terms of flexibility from meetings are that the board can give notice in a manner as practical as possible that you don't even have to give necessarily 48 hours notice. If you feel like you as a board, you need to meet, we need to meet tonight, and all we can give is 8 hours notice, the emergency powers allow you to do it. But it still requires a meeting, and there's nothing about the whole virtual board and virtual membership meeting. So I could see that potentially coming into play. Maybe they'll limit it to the circumstance where it's deemed by emergency and health management officials that it's not safe for members to meet, in person, for example. Maybe that will be the context that you could exercise that emergency power. And then the last thing I have, maybe there will be some flexibility with use of reserves for other than their intended purpose. If you're familiar right now, the only way that you can use a reserves for other than what they're intended for is if you get approval of your membership at a meeting where a quorum is met. Other than that, reserves are only able to be used. So if you've got a painting reserve, it's got to be used for painting unless you have a vote of the membership to use it for something like supplementing your operating account or something like that because people aren't paying their assessments. I don't know that will come into play. The reason why I don't think it's likely because you do have the ability to pass special assessments under the emergency powers. And the statute says that notwithstanding any requirement that might require membership approval in your documents, you as a board can pass a special assessment under the emergency powers. Now, again, remember though that should be in response to an emergency event, not necessarily because you want to pass a special assessment to put in a brand new water slide or something like that. It should be related to something related to the emergency event. So I don't know that they'll put that in, but it's something we've had that question of, hey, because we're in a state of emergency, are we allowed to use our reserves for helping out with our operating account or something like that? And for now, what we've said is there's nothing in the statute that gives you that authority. You got to go through the same process as you normally would, which is getting membership approval, which requires a membership meeting, which technically requires a physical location for them to show up. Hopefully they'll be smart and they'll show up, drop off their ballot if they don't otherwise mail it in, and then you can try to have the vote in that way. So it's not a perfect solution there. So I'm going to keep this up. It has all of our contact information, but we do have a good number of questions that I want to get through. But you see mine and Jim's email addresses. Then you also have Jim O'Donnell's email. He is the VP for this region for the webinar that we're providing today. But let's go through some of the questions that we have, and hopefully we can answer them for you here. David asked if there's a confirmed case of COVID-19 in the association, the resident refuses to self-quarantine, what can the association do in order to protect the association residents or members? You know, the best thing that you could do, I mean, whether or not you can contact law enforcement if it's in violation of anything from a local order, you know, get them involved. It's kind of similar to if somebody's trespassing, we're not telling you to go down and physically try to remove the person that's trespassing. Contact law enforcement or local health officials and see if they can get involved for you. It's not your job as an association to be the police force. We've had some questions of whether or not you can notify the membership if there is a confirmed case. I think that's kind of related to this. We've strongly advised against naming anybody unless you have firsthand knowledge, and even then, I would want to have something from that owner stating that you're allowed to use my name, because if I came in contact with somebody, I would want the community to know that there's a confirmed case. But aside from that, I would not recommend putting a person's name in there.
Yeah, and what a confirmed case is, you know, clients will sometimes approach say, oh yeah, we know someone's been exposed, or, you know, it's been confirmed. Like, well, how's it been confirmed? Well, Joe's sister's Marcia down the way, overheard Johnny talking about it. Well, that's not a confirmation, right? So you got to be careful on that aspect too.
Same thing, Ken asked the question, how does an association handle owners who visit their condos when they're under a stay-at-home order in their home state? Again, it's reporting it to local health officials and law enforcement to see if there's anything they can handle. Aside from that, from an association standpoint, the best thing, if there's a violation of the governing documents, we've talked about that, you'd have to have some type of language that allows you to enforce based upon a violation of a executive order or a law and ordinance or something like that before the association could do anything.
Yeah, and to be clear, no one's prohibited from accessing their condos in this state. We don't really care about what other states have to say about the situation.
We've had a couple of questions from other counties, from Manatee County or from Lee County. We would need to take a look at that. I'm not aware of those specifically. Talk with your manager that you're working with. You should be able to have access to it. If you have a question regarding the applicability to your community, really you're getting into the realm of needing legal advice from your attorney as to the applicability of that order to your community. Work with the people that you're working with your community. And again, if you don't have legal counsel, we're happy to help you guys with it. Gerald asked, what do you think the monetary damages would be for an HOA if you were to sue over pool closure? It's a good question. I mean, it comes down to how do you place a value on, if I'm an owner and I'm being denied access and I pay assessments, what's the monetary damage to that owner? And it's a good question. There's not a black and white answer to that.
No, and it's going to be different in every case. You know, it could be diminution in value of your unit, which if are you in a multi-million-dollar Miami high-rise, your level of damages might be different than if you're in a community that's not a $1 million condominium high-rise, right? So. But understand that in addition to potential damages, they can sue for injunctive relief, forcing you essentially to open them or permit their access. And again, those are going to be attorney fee cases.
Yeah. There's a question of when can we say that our emergency powers have expired? It's basically when the state of Florida, when the state of emergency has been rescinded, basically, or when it's been ended. And that we don't know that. I don't know that that's going to be anytime soon, to be honest. I think that it'll probably be in place for a good period of time. We're seeing local municipalities continuing whenever they have their commissioner or whatever the case may be, city council meetings, that if they have their own local order in place, considering in a state of emergency, I've seen them continue to extend that by certain dates. So just be apprised from a state level. I don't know that it's going to expire anytime soon. I would imagine that it's going to be in place just because of the, I don't want to say flexibility, but what it opens up and what aid you're able to receive by continuing to have it as a state of emergency. I can't see the governor stopping it anytime soon.
No, and from a practical standpoint, we don't really, again, the emergency powers really contemplate, destruction of property and like a hurricane damage situation. So in this situation, there aren't really many emergency powers that we really need right now. Right. So we don't you can operate without even relying on emergency powers as we're sitting right now.
Yeah. James has a good question. Would you consider condominium guest suites, vacation rentals subject to the executive order? Or should they otherwise be considered as a hotel type accommodation? If they are subject to rental restrictions per the executive order, do you believe existing owners could utilize them for personal use? That, I think it depends on maybe the type of, I know there's condotels and there's different of whether or not it applies for your community. And we kind of mentioned how vacation rentals within communities are being treated differently than hotels are being treated. So it would really depend on the type of community you have. But if you have a condominium that allows vacation rentals, it's likely that the executive order would still apply if it's a vacation rental and it meets all the criteria that Jim set forth before, where it's 30 days or less and you're deemed to be providing, transient lodging, for example.
Yeah, in terms of personal use, I mean, if they own the unit, it's not a vacation rental, right?
Yeah. I think I mentioned this regarding Deidre about Lee County. We just need to take a look there. We're not aware specifically for it. One board does not want to charge late fees or interest. They have already removed these charges. Do I tell them otherwise after the motion? I think the question is one board member does not want to, or maybe the board has collectively. I think it is. I think the board has some leeway potentially with the late fees and interest. There is a statutory provision that says you're not allowed to waive the collection of assessments, for example. Now, even in that, there's very limited circumstances where you might have to make that decision if an owner is going through foreclosure, for example, but the board has a little more latitude. Just the thing though is if you're waiving or if you're not charging the late fees and interest, I want to be clear as to when you're going to start those charges back up again and know that you may waive your ability to collect them from somebody that you otherwise would want to collect them from. Like if there's a bank foreclosure and a bank takes title and you can argue that they have to pay those charges, which may be limited in all honesty, they may come back and say, no, this applies to all of us. So just be mindful of if you're having this broad kind of waiver that there's going to have some ramifications. So I'd want to clearly state maybe you're suspending it for a certain period of time, but that they're otherwise going to start again. Or I've seen some communities say, look, we're only doing this for the people that have become delinquent in response because of the COVID-19, not for people that have been delinquent for the last year or so.
Right. Yeah. What we're trying to encourage is, encourage your members to contact you if they're experiencing financial difficulties, as opposed to having some kind of blanket policy waiving anything or suspending anything. And then see, maybe you can implement a policy if you get like 80% of your community saying, hey, look, none of us can pay assessments or we need time or whatever, right?
Yeah. Michael asked if the new collection policy would need to be transmitted to the entire membership. I would recommend that you do so. Whether or not you have to, it's not really an amendment to your governing document necessarily. I've always recommended though sending it out so that there's no question from owners as to what your policy is going to be. I think it's just good practice to do that so that nobody can say, oh, I didn't know that you guys were doing this, that you're going to be sending me letters if I miss a payment after 60 days or something like that. I'll recommend providing that policy. Linda says, let's see, we have 36 individual boards who have a council board that must have the input of each of those 36 boards to pass amendments and changes. The council board was the only board who voted to close and continue to close our amenities. Does this one council board have the right? It's hard for us to answer that because I don't know. It depends on the governing documents and the meeting requirements and so on for that community and for that council. So that's a little bit more of an individual question than maybe what we could provide you from a general standpoint. I would recommend you talk with your community association attorney because it's a little more specific in nature.
Yeah, that's a unique situation, and we would need to look at all the documents forming that relationship to see what authority everyone has.
Yeah. It says, another question is, please define board. Who does this all include? Council officers, presidents of each building, general manager. That would depend. Generally, when we talk about the board, it's the board of directors that's been voted on and elected by your membership to represent the interests of your community. Basically, it's the entity, it's the members that are able to make decisions on behalf of the association. That's generally what we mean when we talk about board. Now, there are different entities that might be administering amenities or common areas. Probably most of what we're talking about is a community association, whether it's a condo or an HOA or a co-op that has amenities where the board of directors has the ability to dictate the operation and the maintenance of those amenities. Now, you might have a separate entity that might own certain recreation facilities or a clubhouse, for example, and that might be separate from a community association context. You might have a CDD, which is a community development district, which is really a quasi-governmental entity that kind of operates like an HOA, but it's still subject to the sunshine laws and requirements for local governments. So there, it just depends on what entity has control over the amenities. But when we define board, what we're generally talking about are usually the members, although it doesn't you don't always have to be a member of your community. You could be an outside, that's usually in the developer context, but we're generally talking about homeowners that have been elected to their board for the corporate entity, which is the association, which is making the day-to-day decisions and the policy decisions.
Yeah, the board as defined by the Articles of Incorporation, creating your association.
Ruth says, if you have a general reserve that is not specific, can the board use it for things not specifically named in the reserve? So that would be, you'd want to have a pretty broadly named reserve. I always call it like the rainy day reserve fund. I know reserve analysts hate seeing those because when they're trying to give you reserve studies are typically based on what are your reserves, what's the components it's based on, what's the useful life, so I know how to tell you how to fund it. That's not to say you can't have that. It's a little more flexible, more in the HOA context, that you might be able to have an emergency reserve fund. And if you're in a condominium context, you're a little more limited as to what you're able to have reserves for. So I would just be cognizant of that, not to try to open up a can of worms to look at, well, shoot, should we even have this reserve in the first place, right? But in general, assuming that it's a valid reserve, you want to look at the basis for what it was formed and what the funding is for before you start using that for, if it's for its intended purposes, for example.
There are limited exceptions in the HOA context, but more likely than not, you should get membership approval to use that for a purpose other than for which it was established.
So the last question we have is, can we legally restrict people from coming in to visit people in our community because of the COVID-19 60 stay-at-home order has been lifted? So be careful if you're talking about restricting access for visitors. It's kind of the thing that we've talked about, which is owners have the ability to bring in guests and invitees, and maybe Jim, this is your time. I made you bring up the trainer example, right, of the right of access.
Yeah. So there's an appellate decision in which there was a community association that operated a fitness center, and one of the members of the community, they owned a lot and were subject to the covenants. They had a personal trainer come in, and that person was being compensated, while the association had this special deal with this other personal training company, and this person was essentially competing. So what the association tried to do was pass a rule saying that, okay, members of the association can't bring personal trainers for hire. So of course this owner challenged that, and what the owner argued, or the member argued, was there's an easement provision in the governing documents that says owners, guests, and invitees have an easement to use the facility subject to reasonable rules and regulations. And the association said, yeah, it's subject to reasonable rules and regulations, and we passed a rule saying that you can't do this. And what the court said was the easement provision in the declaration supersedes and controls over the board promulgated rule. There's an easement in the declaration, and you can't contradict that by passing a rule association. So that's one case in one context. I don't know if I necessarily agree with the holding in that case, if you really consider all the facts, which I didn't go over all of them. But you have to be careful in limiting people's access to the community, because it could be in part dependent on what easements have been granted. In other words, they might have a property right to use that you might not be able to interfere with, or at least lawfully interfere with. So you need to be really careful there.
Yep. Let's see, and then if we didn't have a question, if you had emailed us, we mostly attempted to answer the questions that were either emailed to us or provided in this Q&A. They're all pretty similar and related to what we've been receiving so far. If I didn't answer your question that you may have emailed me, feel free to email me back. I'll see if I can help out with it. We're also providing this webinar tomorrow for another region. I think it's the Southeast region. So feel free, but otherwise, we have our communication information up here in terms of our contact information, I should say. Feel free to email me if you would like a copy of the PowerPoint. I know that Vesta will be posting the webinar, and we will be providing some educational opportunities going forward. Some things we've thought about internally as a firm is, you're coming up on hurricane season, we may be teaching something about your insurance policies. That's a little bit different from COVID-19, but we're always happy to provide educational opportunities. And I wanted to thank Vesta again for organizing this and putting this on and asking us to present. I think it's a commitment for Vesta in terms of showing that it's important to provide you as board members and managers with educational opportunities and staying up to date. And so again, we thank you, and thank you, Jim, for being a part of this. Let's see, I'm gonna stop the share here, and we have both of us up on the screen. So Jim, did you have anything else you wanted to say before we signed off here?
No, I do want to thank you guys for your time. I hope it was very helpful for those who participated. I know I picked up a few things. I had one quick follow-up question, if I may, before
Sure.
we close down. It had to do with the guest suites. And what this is some associations actually have what are basically hotel rooms that they will rent to owners or family of owners or guests that are in from out of town. Would that amenity be restricted under the current orders?
You say the association operates it where they allow certain owners or guests or somewhat to come use them, or?
Yeah,
Like
any owner can rent the guest suite. It's typically under 30 days. It's like a hotel room. So if they have guests that are coming in from out of town and they don't have enough bedrooms in their apartment or condominium, those owners can rent this guest suite for a week or 3 days or 7 days, something like that.
Yeah. So if that particular unit is rented for more than 3 times in a calendar year or fewer than 30 days in each period, then I think the executive order would
Probably
apply.
applies.
Yeah.
Here's
But
some room
it's
for
not a
argument.
unit. It's not a unit. It's an amenity. It's like a guest.
So
It's like a hotel room.
it's by law, it's either a unit, a common element, or a limited common element, right? It's got to be
It's
one of those
a common
three things.
element. It'd be a common element in this case.
So that would be one thing we would verify by looking at the governing documents. But either way, if it is a box of bear that is rented for more than 3 times a year for periods of fewer than 30 days, or if it's held out or advertised for such duration of rentals, then I think the executive order would apply to it. Here's one potential argument that association can make. If an actual unit owner reserves that room, it could be argued that it's not a vacation rental because the owner actually owns a percentage interest in the common elements.
Right.
But that also is dependent upon the precise definition of that box of bear. Is it a unit or is it the common elements? You said it's a common element, but I bet a left leg that it's not. So I think the circumstances are unique, but it sounds to me more likely than not that executive order would apply to that situation. So I don't know that the association could short-term rent that.
Okay.
All right. Well,
Thank you.
Thank you, Jim. Thank you, everyone. And everybody stay safe and have a good day.
All right. Take care, everybody.